much appreciate the chance that the House has to discuss this important question. I think we'd all agree that the introduction of Bill C-30 has caused a powerful reaction around the country, and it's important for the House in discussing this issue, I think, to try to engage not only each other but also to engage the public in a serious discussion of what the issues in this legislation really are, and why it's important that we in this House indicate our understanding and support for the principles in the Charter, for the role of the courts in asserting the role of the Charter of Rights and Freedoms, and in our understanding that there may well be objections to the legislation as it is currently drafted, that those objections need to be treated with respect and with civility, and not with simply a curt dismissal that somehow they represent a lobby on behalf of criminal activity in the country. Mr. Speaker, I want to start by reading into the record the words of Madam Chief Justice Beverly McLachlin in a recent case, the Gombach decision. And that case dealt with the question of the access by police to information with respect to the use of electricity in a particular place because of the suspicion that the House was being used as a grow-up. And the reason for reading this into the record is not because it says anything about that particular case, but because it's a reminder to all of us as to the importance of the issues that we're discussing. And Chief Justice McLachlin uses these words. She says, "Every day we allow access to information about the activities taking place inside our homes by a number of people, including those who deliver our mail or repair things when they break, or supply us with fuel and electricity, or provide television, internet and telephone services. Our consent to these intrusions, in quotations, into our privacy and into our homes is both necessary and conditional. Necessary because we would otherwise deprive ourselves of services nowadays considered essential, and conditional because we permit access to our private information for the sole, specific and limited purpose of receiving those services." She goes on to say, and I quote, "A necessary and conditional consent of this sort does not trump our reasonable expectation of privacy in the information to which access is afforded for such a limited and well-understood purpose. When we subscribe for cable services, we do not surrender our expectation of privacy in respect of what we access on the Internet, what we watch on our television sets, what we listen to on our radios, or what we send and receive by email on our computers. Likewise, when we subscribe for public services, we do not authorize the police to conscript the utilities concerned to enter our homes, physically or electronically, for the purpose of pursuing their criminal investigations without prior judicial authorization. We authorize neither undercover officers nor utility employees acting as their proxies to do so." End of quotation. I think that the issues that are raised in this legislation are significant. And let me just state for the record, Madam Speaker, because I think we all have to be clear on this issue. The purpose of the legislation is to extend the investigatory power of the police over methods of communication in the Criminal Code of Canada. It is not only about child pornography. The short title of the Act is candidly a misnomer. It's not really what the Act is all about. Yes, it covers child pornography, but it also covers any kind of criminal activity. Indeed, it covers activity which would be covered by the Anti-Terrorism Act. It covers activity which is covered by the Competition Act, to give you an example. So, Madam Speaker, this really has to do with extending the capacity, the power of investigation and intrusion into very extensive matters covering all methods and means of communication. Let's be clear. There are, under the current provisions of the Criminal Code, which have the support of all members of the House, we grant to our police officers and to our security officials under the CSIS Act, we grant them the power to watch what people are doing, and then if they feel that there's criminal activity underway, we grant them the power to go to a judge and ask the judge whether or not it is possible to intercept, in the case of the current Criminal Code, to intercept phone calls, other forms of communication. So no one on this side of the House is suggesting for a moment that it is somehow inappropriate in the circumstances where there are clear and probable grounds to believe that a criminal act is either being performed or is about to be performed, that it's inappropriate for the police to go and ask for the powers to look at what's happening. That is not inappropriate. And so it is important for every one of us to understand that the Charter, insofar as it has set out some of the protections for privacy and some of the concerns that that the House of Commons and the Senate had with respect to entrenching certain critical individual rights, and we are this spring celebrating the 30th anniversary of the Charter, it is important for us all to recognize that the Charter itself simply expresses and codifies what in effect has been the law of Canada, and indeed the common law throughout countries that follow the common law, and which applies, the Criminal Code applies to all of the jurisdictions in Canada, what in effect has been our jurisprudence for literally hundreds of years, which that there are limits on the powers of the state to intrude into the privacy of people's homes. And if you're going to break through that line and cross over that border and that frontier, you have to have the approval of the courts before you can do so. Now, the issue which is raised most directly by Bill C-30, Mr. Speaker, is really the issue that's contained in Section 16 and 17 of the Act. And those are the provisions which say that either in the case of Section 16 in writing, or in the case of Section 17 orally, on written request by a person designated, every telecommunications service provider must provide that person with identifying information in the service provider's possession or control respecting the name, address, telephone number, and electronic mail address of any subscriber to any of the service provider's telecommunication services, and the Internet protocol address and local service provider identifier that are associated with the subscriber's service and equipment. That's Section 16. On Section 17, it says any police officer, not just any authorized person, but any police officer can, if they have reason to believe that reasonable grounds that the urgency requires that they get the request right away, it allows them to get that information simply by making a phone call and saying, we need this information right away. Now, Madam Speaker, there's room, surely, for a legitimate debate about whether or not the obtaining of that information is in fact a breach of privacy.
We have the Charter of Rights, and before the Charter of Rights, there was the principle within our system, our legal system, and it was the primordial right that the state cannot intervene in the private business of individuals without having the necessary authorization from a judge. And that is clear. And that is the problem that we have. That is, that we believe that there needs to be a debate, a clear civil debate that clearly states that we recognize that people are entitled to their privacy. And even further than that, we would say that with Section 7 and 8 in the Charter, we must clearly say that the law should clearly protect privacy and individual rights.
Just to be clear, because I know this debate today can go in many different directions, it's very important for the House, I think, to treat the views of those people who are concerned about this legislation, Madam Speaker, with a degree of understanding and respect. Let's be clear. We on this side would never say, and are not saying, that we do not believe that there are grounds and times and ways in which, of course, the police and other investigating officers have a right to have access to information which is held by a service provider. That's the same way as saying that a telephone company has to allow for the possibility of an interception of a telephone call, and if, in fact, criminal activity is not simply taking place on the telephone, but it's taking place on the Internet, or it's taking place by means of a cell communication, or it's taking place by some other digital means, of course it's reasonable for the police to say, we have to have access to that information in order for us to be able to know what's going on. The key issue is the House prepared to say to Canadians, that can happen, but it can't happen without prior judicial authorization. It's really a very specific issue. And when we come down to looking at all the other provisions of the bill, it's a complicated bill. It's a long piece of legislation. It's not a small piece of legislation. So I want to say to the government, we welcome the fact that in response to this literally unprecedented wave of objections to the bill, the government has decided to put the bill into committee before calling it for second reading. I think that's a good idea. I would argue that actually that's a good idea for a lot of other kinds of legislation as well. We'd be glad to see it being done on other occasions. And I say to the government, we think it's important to do it. Now, let me just say to you, Madam Speaker, that we on our side are committed strongly to having this discussion and at least to recognizing that there is a legitimate basis for the concern on the privacy argument. And if we were to simply reject that right to privacy, we would be flying in the face not only of the Charter, but of the Charter as it has been interpreted by the Supreme Court of Canada in literally dozens of decisions that it has taken since the House voted on the Charter in 1981. I hesitate to even mention this point, Madam Speaker, but I happen to be sitting not very far from where I'm standing today and voting in favor of the Charter and the patriation of the Constitution at the time that the House was debating that point. And I must say, and I invite the member opposite if he wants to go back and read, I'm not going to quote my own words at the time, but if he wants to read the speech, he's certainly going to, I recommend it to him in terms of his level of enlightenment. But I think it's important. I think it's important, Madam Speaker, for us to understand that when people, and I've heard members who are sitting in this House criticize the Charter, when people say the Charter is something which works on behalf of criminal activity and it doesn't work on behalf of others, that is simply not true, Madam Speaker. It's important for us to understand that when we are arguing on behalf of privacy, we're not arguing on behalf of criminal activity. We're arguing on what are the borders and boundaries of the distinctions between what is private and what, in effect, the state has reasonable grounds to have access to. What are the tests that the state has to meet in order to cross over that line? Well, the courts have said there are tests that people have to meet. The courts have said we do insist that the police follow these sets of rules and regulations. And yes, in circumstances they can be difficult and they can be onerous. And yes, if the steps are not followed properly, then there are decisions that are made which in effect say there has to be a new trial because in fact the rules were broken with respect to what was admissible as evidence and what was not admissible as evidence. There's a name for that in our society, Madam Speaker. It's called the rule of law. It's called the rule of law, and it means effectively, it's not, we didn't give the courts some sort of new role that they never had before in the Charter. The courts always had the role and the responsibility of saying that when legislators go too far or when legislators are unwise in how they proceed, then there needs to be a step back. And there have been lots of times in Canadian history, going back long before the Charter, when the courts of this country said, you can do this, but you can't do that. Perhaps there's some members opposite who may remember the infamous Alberta Press Bill, where the legislature of Ontario, under the, I guess, intellectually precedent government of the one which is opposite, the Social Credit Party of Alberta, said that the press had to give the government side of every story that they were running. Wow. That the press had to provide for the alternative official position in order to allow for balanced reporting. The Supreme Court of Canada said many decades ago, no way you can do this. It's an infringement of the freedom of the press. It's an infringement of freedom of speech. Similarly, in Quebec, long before the Charter, when Premier Duplessis personally said that Mr. Ron Carelli was because of his association with the Jehovah's Witness, could have a restaurant, but the restaurant could not have a liquor license, the Supreme Court, in a very famous judgment, said, sorry, you can't do that. You cannot use a completely irrelevant argument in order to stop somebody from pursuing their legal rights. What the Charter was intended to do, and I believe on balance what it has done, is essentially to entrench and formalize the rights we've always known were there. The Charter is an effective guarantor, but frankly, Parliament has to be a guarantor as well. Madam Speaker, it's so important for us in this House to understand what is at stake in these discussions. It has to do with our common commitment to the rule of law, our common commitment as a Parliament to the law of Canada, which includes the Charter of Rights and Freedoms, and our common commitment to civility in how we treat the people who are on the other side. And I think that there's no reason why the government should be voting against this motion. There's no reason for anyone in the House to vote against it. It states out in a very balanced way the principles of the Charter, the issues that are at stake here, and why it is so important for us as Canadians to deal with this issue in an intelligent way. The police have to be able to do their job. We need to be able to deal with, yes, acts of violence, acts of terrorism. We need to be able to deal with, yes, child predators, yes, crimes that particularly are inflicted on children, but we need to do it in a way that fully conforms with the rule of law in our country. Naturellement, nous allons suivre.
Naturally, we will follow the debate with a great deal of interest. But as I said previously, in the motion introduced today, there is clarity, yes. Yes to privacy, yes to the Charter of Rights and Freedoms, and yes to the important notion that we can all agree on, the necessary balance, the role of the courts, which is essential, and the respect for citizens and a civil debate on this issue.
Madam Speaker, let me just say this. There's been a lot of emotion around this debate. I think it's important for us to understand where some of that emotion comes from. We need to be able to deal with these issues with mutual respect and to look carefully at the bill, to study it carefully. I can assure the government we're going to be doing that in a responsible way in our role in the opposition, the Liberal Party. And we're going to continue to work for a criminal code and a working police force and the protection of Canadians that also guarantees the rights that all of us have to privacy, and to the rule of law. Thank you, Madam Speaker.
Questions and comments? The honourable member for Burlington.
Thank you, Madam Chair, and I do appreciate the member's opposite speech and his outline of the motion that's here today. And I do have a practical question, one that I'm trying to remove the rhetoric from. I think it was an important point that he was. Well, maybe you should wait for my question before you start laughing. You did talk about, and I have read it over, and you did talk about Section 17, and I'd like to talk about Section 17. My reading of Section 17 is that in an emergency case, the police have the ability to go and get that information about being able to track somebody down. For example, and I'm not trying to exaggerate here, just using it as an example, use examples, that if an individual who is a known child predator has abducted someone, the police, under my reading of 17, would be able to go and get that basic information and go and try to attempt to find that individual and resolve that particular issue in an emergency case. Based on my understanding, if I'm wrong, you can enlighten me, what is the Liberal Party's suggestion in terms of changes to Section 17, to make sure that we're able, that the law enforcement officers are able to act quickly to be able to resolve those types of issues? Thank you, Madam Speaker.
The honourable member for Toronto Centre. Before he answers, I would just remind members that they should address their comments through the chair. Thank you.
Madam Speaker, first of all, I appreciate the question from the member for Burlington, and I know some of the emotional circumstances that he must be going through in his own constituency, and our hearts are with him and his fellow residents of Burlington as they deal with the tragedy of the recent crash. But I do want to answer his question, and I think that he's right when he suggests that it is in an emergency situation where that's exactly what police would do. But under the current criminal code, we don't give police that power. And you can get a judge in an hour. I mean, there are ways in which very, very quickly one can go to a judge. I will only say to the member that I'm looking forward to listening to people. I'm looking forward to listening to representatives of the police forces across the country and say, what are the circumstances in which, how would you compare this with what you currently have to do under the criminal code? I think these are perfectly reasonable questions, but I think the reason that there's a lot of concern out there is we generally speaking have not authorized handing over this kind of information without the authorization, without prior judicial authorization. And that's the issue, is what point do we cross that line? That's what we have to discuss. But we've got to be able to discuss it without being accused of being such terrible people. I mean, it would be nice to be able to have this conversation in a way that allows us to do that.
Good point.
Questions and comments? The honourable member for Surrey North.
Thank you, Madam Speaker. Like a lot of the Canadians out there right now that are appalled with this introduction of this bill, I am also appalled at this bill that's being introduced by the Conservatives. It treats law-abiding citizens like criminals, and that's wrong, Madam Speaker. Madam Speaker, I'm fairly new to this House, and I've done a little bit of research, and what I found out was that this Lawful Access Act was introduced by the Liberals in 2005. Not only in 2005, they introduced it again in 2007. So my question to the honourable member is, what has changed in this legislation that they are now opposing this? Why are they flip-flopping on this? What are the reasons for it? Thank you, Madam Speaker.
The honourable member for Toronto Centre.
Well, first of all, Madam Speaker, I'm not sure there's been a flip-flop. I think what there is since 2000. First of all, it's interesting that legislation has been around since 2005. A question that one might ask is, if this bill has been such an urgent requirement, why has it taken 7 years for it to come to the floor of the House? And there'll be lots of explanations for that. But I take the member, if he wants to get into a partisan debate, he can. I don't think it should be any surprise to anyone that governments facing a complete transformation of the technology that is now being used by Canadians, and hence by some criminals, would seek to update legislation with respect to seeking surveillance, the ability to carry out surveillance activities on using technologies that were not available in 2000 or 1995 or 1990. I can assure the honourable member that in any government where the NDP has been involved, the police have been very concerned about their ability to do their job when criminals are working ahead in terms of technology and governments are way behind in terms of their access to technology. So this is not a new issue for Canadian police forces. So all I can tell the honourable member is that my views on this matter have not changed. My view is it is not unreasonable for governments and for police forces to be looking at the ways and means in which they have to be able to deal with criminal activity using the latest technology and sometimes using it in very destructive ways. On the other side, my view is equally clear. We have to do it in a way that's consistent with Canadian legal traditions and with our protection of privacy. So it seems to me you're always, in every piece of legislation like this, you're always trying to find the right balance. And my concern is this legislation, as it is currently drafted, doesn't reflect that necessary balance.
Questions and comments. The honourable member for Ottawa South.
Well, thank you, Madam Speaker. I'd like to congratulate my colleague from Toronto Centre for such a balanced perspective on really what can be described as a moving target for Canadians. Technology is evolving very quickly. Knowledge is doubling every 18 months. I'd like to raise two quick points with him, if he could take a second to elucidate for listeners and for Canadians. One is, how important is it for Canada to get this right, Madam Speaker, because of the extent to which developing countries, emerging economies, countries around the world are looking to Canada as a touchstone for balance in terms of privacy, the protection of our right to privacy and access to this information. And perhaps the second point, if you could take a second to address, is we often hear from the Conservative government how perhaps mistrustful they are or distrustful they are of the existing members of the judiciary. They've often talked about judges making law. They've often talked about Minister of Public Safety criticizing, for example, for years, members of the judiciary as being too liberal, small L, and so on. So I wanted to simply ask my colleague if he could expand on that to help us understand, should we be addressing this at committee as well?
The honourable member for Toronto Centre.
Well, I appreciate those questions from my colleague from Ottawa South, and I want to say, first of all, of course it's important that we take this seriously. If you look at legal decisions being taken around the world, the Supreme Court of the decisions of the Supreme Court of Canada are cited in almost every jurisdiction in the world as models of finding a balance and expressing principles that are deeply entrenched in our traditions. And that, yes, they have to do with the Charter, but they don't, as I said in my speech, they don't only have to do with the Charter. And I'm looking at my colleague from Mount Royal because I've always regarded him as a bit of a, when I go back, he'll give me a grade on what I had to say with respect to what happened. He'll tell me where I was right and where I was wrong. And so will my colleague from Vaughan as well. It'll be a different grade from him, but it's okay. He and I have had a relationship debating these issues going back many years in the province of Ontario. But I do think it's very important that we get this balance right. The second thing I would say is I would hope that this government by now would realize that attacking the judiciary is not something that anybody should do. We have a very fine judiciary across the country. I don't agree with every judicial appointment that's been made, and I suspect that the Minister of Public Safety doesn't agree with all decisions, the appointments that were made prior to his coming into office. But the fact remains is that the courts have usually got the balance pretty right. They have to make unpopular decisions sometimes. They have to make difficult decisions. We have a very strong appeal court system in our country. We have a very strong Supreme Court of Canada. And I think it's very, very important for us to recognize the importance of the independence of the judiciary as being a fundamental principle of the Canadian Constitution. Yes, courts will often have what they think is the final word. Parliament will have an opportunity to respond sometimes, but it's very, very important for us to realize that what helps to define our democracy is the independence of our judiciary and the quality of the people who are currently serving on our courts. Thank you.
Resuming debate, the Honourable Minister of Public Safety.